Good day, Thomas Jefferson Hour podcast listeners. And as always, and I really mean this, thank you for listening. This week, we talked with President Jefferson about the Supreme Court, and it was a great conversation. Thank you so much for that, Clay.
It reminds me, Jefferson appointed 3 people to the Supreme Court in the course of his time. Actually, they served for a long time, one 17 years, one 19 years, and one 30 years. They're all basically, I hate to say it, historical non-entities. And they all disappointed Jefferson in some way. He wanted them to be much more states' right, 10th Amendment sorts of people than they turned out to be. And he wanted them to be more severely for limited government than they turned out to be. And it reminds me of something that is said to have been said by President Eisenhower. He said, I only made 3 mistakes in the course of my presidency, and all of them are on the Supreme Court.
I love that. There's one thing, there's a lot of really important things that Jefferson said this week, but there was one thing that you said that really kind of stuck out to me and that I want to hang on to. And that was how the humanities are helping you to understand the tumultuous times that we're going through now. And I think that's so true. And I try to do that. And I have to say that I've come up with a much better understanding, viewing it through that lens of what the two parties each are so passionate about believing. I feel like I understand each side better through that lens.
I so believe that. I'm so perplexed, bewildered, disappointed, disillusioned, cynical.
You can't be. You're the humanities scholar. Come on, man.
But those are my natural human feelings. But here's the good news. Instead of just wallowing in that, I get to go back. This is what I get to do for a living. I get to go back and look at it from a historical framework. And when you do that, some really interesting things happen. So first of all, we discover that the politicization of the judicial system is not new, that it was already deeply politicized in the administration of John Adams, and his midnight appointments were partisan appointments, and Jefferson resented them. And there had been the Judiciary Act of 1801 by the Federalists to try to forestall Jefferson's plans. And then when Jefferson came to power, there was the Judiciary Act of 1802, which repealed a lot of the provisions of 1801, so it was Federalist versus Republican. And that's when the number of Supreme Court justices went from 6 to 5 to prevent Jefferson from making an appointment. Then they took it back to 6. The politics have been vicious and partisan from the very beginning, and we should never pretend otherwise. I know sometimes we think we live in this incredibly difficult time, but the fact is the past is prologue, and in many regards, we've been there before. The second thing you learn is that this debate actually happened, that Jefferson wrote this letter to Mrs. Adams. You and I have talked about that exchange before. Mm-hmm. And he said that one thing and one thing only that your husband did really upset me, and that was the midnight appointments. And she, to use the most vulgar phrase, she tore him a new one. And she wrote to him and said, hey, read your Constitution, buddy. He was president right up to the moment he wasn't. It's his duty to fill vacancies. Don't be telling me that was not a good thing to do. That's what a president is supposed to do. And she was right, and Jefferson was wrong. But Jefferson was right.
And nobody talked to Jefferson like that, except Abigail Adams, right?
And he was so shocked by this that he started to backpedal, and eventually he just said, enough. And when he reconnected with John Adams, the deal was that he didn't have to address her because he thought they were like sworn enemies. She's one of the reasons why it took so long for the friendship between John Adams and Jefferson to rekindle, because Jefferson thought, well, that guy's married to a tough one, and she's really awful to me. So there's that. But Jefferson was right and Adams was wrong, that it's only polite, if you really care about the country, to step back and say there's a vacancy.
I don't want to give too much away from the show, but
I'm just saying that they were all right, and that the humanities contextualize this and deepen the conversation, and in some ways cheer us up, because we got through it then, we're going to get through it now, and everybody's right and everybody's wrong, and anyone who takes a completely righteous opinion about this is not understanding the complexity of American history. That's the point. And so this has helped me so much in the last couple of years. I get to see the world through this lens, and I get to read the story of American history for a living, and then try to bring it to all of you and to help you, I hope, clarify these situations. But I could not have said what I said today about where we are if it hadn't been for studying, preparing for this moment, not only for years, but specifically for this program. And I just do really hope, David, that it helps everyone who's listening to the show today feel I know more than I knew going in. The situation has been clarified. In some sense, you have to cheer up over this. There's no one answer to a situation like this. It's very complex. That really, I think, is why the humanities exist, and I thank God that I've had a lifetime of being able to really swim in that pool.
It's about time for us both to have our Hamiltonian moment, but before we go there, I would say that there is a comparison between what's going on now with the current administration and what Adams did. Wouldn't you?
Yes, very, very much.
So this is not new. It's been done before, and it'll undoubtedly be done again. Having said that, into our Hamiltonian moment, I want to thank everyone sincerely, those of you who have chosen to support the Thomas Jefferson Hour. You can do that by going to jeffersonhour.com, click on donate, join the 1776 Club. It'll unlock our archives, and there are tons of shows. And I know that there's a number that we've done in the past that are relevant to what's going on today. And we do so appreciate your support, and we need it. And we have every intention of continuing these discussions. In fact, Clay and I discussed prior to the show about there may be a need to do some special editions and post them on the website. With that, sir, it's your Hamiltonian moment.
Yeah, let me reiterate that we may be doing some special editions of the Jefferson Hour between now and January 20th. Just trying to ground all of the many, many crises that are ahead of us here in bona fide American history. And I pledge to try to be absolutely true to the world of Thomas Jefferson, to represent him exactly as he would have seen questions like this, as I hope I did today, that the president has an absolute right to appoint the next person. But whether that is something that morally and civilly the president should do is also an interesting question. So stay tuned. We may be doing 1, 2, or 5 special editions of the Jefferson Hour between now and the end. And I'm also, David, planning to do a November 4th Zoom meeting. I hope you'll be there. In the afternoon of November 4th, that's the day after the election, a kind of debriefing. Where are we? Just to let our listeners come in on a Zoom. We'll set this all up, and it'll be on the website.
Wow, that's ambitious. Yeah, that would be fun.
And we'll record it. But I want our friends around the country to be able to participate in that 2-hour event on the 4th of November, in which we debrief the election and we just begin to process what happened and what does it mean. We probably won't even know the results fully, at least on that occasion. So stay tuned for that. Here's really an interesting thing, David. Beginning the week after the election, I'm going to do a 5-week online course on the Constitution and the future. What kind of amendments might we want to make to the Constitution? Where are the flashpoints in the Constitution? This will be, and I've got some really extraordinary books for us to read about the making of the Constitution. It'll be coming right after the election, these 5 weeks, and it'll be an attempt to say, what about the War Powers Act? And what about the impeachment clause? And what about the emoluments clause? And how easy or hard is it to amend the Constitution? And should we have a constitutional convention from time to time? And what does the Second Amendment mean in the 21st century? And what is the Ninth, etc. And so this will be a 5-week online humanities course. There'll be a fee, and then we'll meet, and there'll be 4 books. And I think it's going to be absolutely splendid to talk about sort of Constitution 101, but it's also where are we now? Where are we now? And it's not just this election. These questions have been percolating for 30 or more years. And so watch for that. That'll be on the Jefferson Hour site. The 3 winter encampments are coming, and we have opened a second one on J. Robert Oppenheimer. So if you're interested in Oppenheimer, the making of the atomic bomb, the decision to use the atomic bomb, and where the nuclear precipice is today, that's in, I think, the 24th to the 28th of January out west of Missoula, and there are a few places left on that. So lots and lots of things for people to do and sign up for, beginning with the Homer class, which is now full, but then the Constitution class, the 3 winter encampments. We've also opened up a Salmon River of No Return float trip next summer as a second trip. So much going on. It's all on the website, jeffersonhour.com. So thank you, David. It's I don't get to see you, but I did feel like Jefferson. And so getting in and out of costume virtually is quite an interesting thing. And I can't wait till next week. a return to our friendship with Dr. Joseph Ellis.
Very good, sir. Thank you for all the updates. And now let's go to this week's show. Good day, citizens, and welcome to the Thomas Jefferson Hour, your weekly conversation with President Thomas Jefferson. Mr. Jefferson is portrayed by the award-winning humanities scholar and author Clay Jenkinson. I'm your host, David Swenson, and with me today is President Thomas Jefferson, and good to hear from you, sir.
Good to see you, my dear citizen.
Mr. Jefferson, I hope all is well at Monticello and the fall weather is agreeable to you, sir.
This is a great time of the year at Monticello. I love the autumn. I love all of the seasons of the year. The spring when we plant and we're filled with such optimism about all of the variety of vegetables that we put into the ground. And then, of course, the end of the year, the time of great abundance. America, above all places in the world, is a landscape of abundance. It's a cornucopia of production, live animals, fruit trees, vegetables, and of course our crops, tobacco and wheat and barley and vetch and so on. And they all come to fruition at slightly different times of the year, but there's a reason that in almost every culture of the world there are harvest festivals. In the United States, you celebrate your harvest festival fairly late, at Thanksgiving at the end of November, but almost every society that has ever existed on Earth has celebrated the harvest because it's that moment when not only do you have a sense of the fertility of the soil and the uniqueness of man, in that he cooperates with the land. You know, he plants seeds and they come up and produce an abundant crop. No other creature in the world does that. But it's also an assurance, especially in the centuries before your own time, that we're going to get through the winter, that we're not going to starve. And famine and starvation have been a very significant factor in the history of humanity. But in the New World, we are so blessed with a largely fertile soil that has almost never been farmed. Such farming as native peoples did was on a very minor scale. And so we are uniquely blessed among all of the nations of history. And it's not that hunger and famine are impossible in America, but they're much less likely here than anywhere else in the world.
I love the autumn too, sir. Mr. Jefferson, I'd like to speak to you today about the Supreme Court. It's on many citizens' minds because we've just lost a very notable and unique Chief Justice. And my understanding is that this is the only court specifically established by the Constitution.
Well, the Constitution in Article 3 contemplates a court system, but it's quite vague and general and did not specify much by way of detail. So the first Congress of the United States passed the Judiciary Act of 1789, and that was intended to create the infrastructure, the system for American court systems, U.S. court systems. And George Washington, as the first president, of course, filled every available seat. And although he was nonpartisan, his appointments would later be regarded as Federalist appointments because over the course of his two terms, George Washington became more partisan. And instead of just being a sort of patriot king who had no party, he became increasingly associated with the party of Colonel Hamilton, which you know historically as the Federalist Party. So the system really has a double constitution. The Constitution itself is not very specific, but the Judiciary Act of 1789 is almost a mini constitutional convention, that first Congress, and it established many of the departments and their procedures, and those precedents which were set by the first Congress have continued all the way down to your own time.
And the number of justices is determined by Congress, not the Constitution, correct?
The Constitution is silent on this question. The Congress of the United States could set the number of Supreme Court justices at 6 or 5 or 10 or 400 if it wanted to. The number is absolutely arbitrary, determined by congressional legislation. Of course, that legislation must pass both houses, and it must be signed by the President of the United States. The first number established by the Judiciary Act of 1789 was 6, The politicization of the courts began almost immediately. When it was clear that John Adams was not going to win a second term and that I was going to become the new president of the United States, which was effectively the first transfer of power in the history of this country from one party of men to another party. So it was a very important moment of transition. Would it be peaceful? Would there be continuity? Would there be discontinuity? How disruptive would it be? Etc. The questions of a peaceful transfer of power are some of the gravest and mightiest questions that any society ever has to ask. And as you know, in Europe, this is usually attended with cataclysm. In both Britain and France, the transfer of power in first the 17th and then in France the 18th century occurred by way of the decapitation of the sitting monarch. So we were all very concerned about this. And when I was clearly to be the next president of the United States, the Federalists in the Congress, to forestall me from naming people of my own stamp to be Supreme Court justices, reduced the number from 6 to 5. And so that meant that when whoever retired from the bench during my administration, I couldn't replace him because the number had been reduced from 6 to 5. So it was effective in attempting to keep me from naming people of my own political philosophy to the High Court. Then in 1802, my Congress, I had a very friendly Republican House and Senate. They passed the Judiciary Act of 1802, which increased the number back to 6, and by the way, eliminated some of the courts that had been set up by the Federalists. I think that they had overreached and had created too many positions in the U.S. court system, not at the Supreme level, but in the circuit and district courts. So the politicization of the judicial branch of the national government began early, and it has continued throughout American history. So I know that the number in my time went from 6 to 5 and back to 6. It later went up, I think, all the way to 10. I believe it was after your Civil War in 1869 that the number was set at 9 and has remained 9 ever since, although there was an attempt in the 20th century to increase the number, but that was not permitted by congressional action.
History tells us that the first Chief Justice was John Jay. Can you tell us anything about the man and how he was selected?
Well, he was chosen by George Washington. Jay is a Federalist. He's a New York High Federalist. I had great admiration for him. We disagreed politically, but I understood that he was what we in our time called a man of parts. He was a man of extraordinary capacity. And when I was Secretary of State, he was the foreign minister under the Articles of Confederation, and we had a very useful correspondence with each other. So he was a very good and admirable man and was named by George Washington to be the first Chief Justice. The president, I should say, whoever that president is, has a right to surround himself with men of his own stamp. Elections matter. The president is entitled to create his cabinet of people that share his political philosophy. And all of the positions of federal appointment, and there were several hundred in my time, mostly minor, the president is entitled to fill with people who are harmonious with his program. And when vacancies appear in the courts, whoever the sitting president is has a right to put people who share his outlook and his policy on that court. The Senate must confirm. So the Senate does sit in judgment of this. The president is not entitled to do this by himself. But I said, and I mean this very emphatically, that unless the Senate finds something wrong in the character or the competence of the nominee, they must confirm. The Senate, in my opinion, is not entitled to deny the president his nominees at any level unless the Senate feels that that person is not competent or has some other issue of character that would impede his capacity to do good work on behalf of the country. But if the president is a Federalist and the Senate is a Republican Senate and the president chooses a high Federalist to be a nominee for the court, in my political philosophy, he is entitled to that. That's one of the ways in which elections matter. And the Senate is not entitled to disagree with a nominee on a question of politics or policy.
Just to be clear, Mr. Jefferson, because this has become quite controversial during my time, you are saying that a president not only has a right to appoint a Supreme Court justice during an election year, it's almost a duty, even if the election has already occurred.
Yes, a president is a president from the moment that he has been inaugurated until the moment that the next president is inaugurated. The Constitution empowers that being to make all the decisions that a president makes during that time, and therefore he has a constitutional right to appoint individuals to fill vacancies wherever they might occur in the federal system. Nothing in the Constitution suggests that the president does not have that right, and if the Senate, of whatever party, is willing to confirm those nominees, that is constitutionally legitimate, and there is no effective constitutional argument against that sort of a filling of a vacancy. I will say that I believe that a president, any president, should try to defer decisions of this magnitude until after the next inauguration. And that's what I did. Even when I handpicked my successor, James Madison, he was my closest friend. It was clear that he was going to follow my lead in all that he did, that we were of the same political viewpoint, and there was deep harmony between us. But in the last year of my presidency in 1808, I did not make any significant appointments or decisions that could tie his hand when he became the fourth president of the United States. And I will say, too, that I resented John Adams' midnight appointments after the election results had become clear in 1800. He filled a number of judicial offices, including that of the Chief Justice of the Supreme Court, with people who were not only not of my political outlook, but were my sworn political enemies. And that only I considered to be an ungentlemanly thing that John Adams did that hurt our friendship. But he was within his constitutional rights. There is no question about that.
Thank you very much, Mr. Jefferson. We need to take a short break. We're discussing the Supreme Court this week with President Jefferson, his personal recollections and observations. We'll return to this conversation in just a moment. You're listening to the Thomas Jefferson Hour. Welcome back to the Thomas Jefferson Hour, your weekly conversation with President Thomas Jefferson. And Mr. Jefferson, welcome back.
Thank you, sir.
Mr. Jefferson, I understand your thoughts about presidents and appointments of judges to the Supreme Court. In fact, sir, you made 3 appointments, did you not?
That's correct. Actually, I made 19 appointments to our judicial system at the national level, 7 to the circuit court system, 9 to the district court system, but the most important of these appointments, of course, are to the Supreme Court. Remember, there were 6 positions on the Supreme Court in my time, and I nominated 3 people who were, in fact, all confirmed. The first was William Johnson of South Carolina. He was appointed and confirmed in 1804, at the end of my first term. The second was Henry Brockholst Livingston of New York State. He was appointed in 1806 in the middle of my second term and confirmed by the Senate. And the third was Thomas Todd of Virginia and Kentucky, and he was nominated and confirmed in 1807. So 3 members. I will say this, they all, in some respects, proved to be disappointments to me. I wanted my appointments to be strict constructionists with a deep commitment to state sovereignty. I believe that Virginia is a sovereign state, and Georgia is a sovereign state, and New York and New Jersey are sovereign states, just as France and England and Sweden and Finland are, and that they come together under our system for certain very limited national and international purposes. And so I wanted my justices to be strict constructionists who would adhere to the idea of the 10th Amendment, that the powers not delegated specifically to the national government belong instead to the individual states. And all 3 of them veered somewhat from this political philosophy. And that does raise a question, sir, which is that once you appoint someone to the court and he is confirmed, he serves for life, and there is no check on the independence of his thinking. Whatever he may assure the president who nominates him or the Senate of the United States, the minute he's on, he can go in any direction that he pleases, and there is absolutely nothing that the people who put him there can do about it, and he serves for life on good behavior, which can mean 10, 15, or 20 years.
This brings up a point that we've touched on before. In my time, and please correct my thinking, sir, if you think it necessary, but I know that you have issues with lifetime appointments on the court.
Of course.
From my viewpoint, it gives an individual a certain independence of thinking. They are allowed to do what they think best, to make judgments based on their own character, which in a way, sir, strengthens the argument that character is such a large part of the confirmation process.
Well, several things there. I do certainly believe that character is essential to naming people of such power. The goal, the principle in this is a difficult one. You want your judicial system to be independent of the day-to-day will of the American people, because sometimes they're going to have to defend the First Amendment or the Second or the Fifth Amendment. They're going to have to say that a bill passed by Congress is not in keeping with the fundamental constitutional law of the country. And so you want them to be independent of the will of the people so that they have the space and the courage to do the right thing on questions of adherence of legislation and administrative acts to the strict principles of the Constitution of the United States. You want them to be independent, but you don't want them to be too independent. You want them to have to listen to the sovereign and do everything in their power to affirm what the people want as they express it through the national legislative system. If you make it too independent of the people, it becomes a tyranny. If you make it too dependent on the people, it becomes slavish and can no longer show moral courage in the face of things that go wrong in day-to-day legislation. So finding that balance is very, very difficult. I personally think that life tenure is a mistake. And if somebody serves on the court for 30 or 40 years, that's longer than a generation. And remember that there is no recall, that once that person has been confirmed, he's going to serve for life. And what if he turns out to be somebody whose views are really not constitutionally at odds with the people, but politically at odds with the will of the people? That's a long time to put up with a bad choice. And so it seems to me that there should be some way of limiting the terms to the Supreme Court. There is an impeachment possibility, but as I understand it, no Supreme Court justice in your history from 1788 until your own day has ever been successfully impeached by the United States Congress, by the House to indict and the Senate to convict. That's frightening. You can't tell me that of all of the justices of the Supreme Court from the beginning of the constitutional system until your own day, there has not been someone who richly deserved to be impeached and removed.
Well, I grant your point, sir, and I think it is a good one. I also do think that a lifetime appointment relieves the opportunity for political pressure in some ways. But be that as it may, to summarize, sir, you named 3 men to the Supreme Court, and Congress gracefully approved your appointments. The Senate recognized that you had a duty to fill vacant seats, and you had a right to surround yourself with people of your own political persuasion. And I'm hearing you say that you believe so strongly in the sovereignty of the people that you nearly subscribe to Rousseau's principle that the people are always right, even when they are wrong.
Yes, except that let's say that there's a war scare, as there was in 1798. And let's say that the Congress of the United States passes the Sedition Act, which said that writing anything that could be construed as critical of the Adams administration was illegal. And let's say then that law is enforced by the lower court systems, which, by the way, all happened. There was a quasi-war with France. The Sedition Act was passed. I believe that it's palpably in violation of the First Amendment of the Constitution, that it was worthy of the 9th or 10th centuries in the Dark Ages. In that case, you want your Supreme Court to say, wait, for whatever reason, Congress has passed a law that is palpably in violation of an important constitutional principle, the First Amendment, the right to freedom of expression. Therefore, we, the court, must remonstrate. We must criticize such legislation because it is palpably out of harmony with the more fundamental law of the nation as expressed in the Bill of Rights. That's what you want the courts to be and to do, because there will be times, and this happened in 1798, it happens periodically in any society, when there's a war scare, when there's a domestic concern about insurrection, as in the Shays Rebellion or the Whiskey Rebellion, when some momentary perception creates a wave of error and fanaticism that sweeps through our government councils, and suddenly legislation is passed which violates constitutional principles, then you want an independent judiciary that doesn't have to face re-election in 6 months or 2 years. You want that judiciary to be able to step up and say, we hear you, but we cannot affirm this because it violates a fundamental principle that you have all ratified, by the way, in your Constitution. So I do think that the justices need to listen to the people, and they need to understand that legislation is important, and that in our system, the legislative branch is meant to be supreme. But they also have to have some sort of a bedrock set of constitutional principles that they protect against what might be called the tyranny of the majority.
Earlier in our conversation, you expressed some dissatisfaction with Mr. Adams for his what you call midnight appointments, particularly that of Chief Justice John Marshall. And it doesn't take a lot of effort to find out why you were upset with this. I mean, the Marshall Court really defined its own power, particularly through judicial review. In the case which I'm sure you would be anxious to speak about, Marbury versus Madison, the Supreme Court established that they could overturn a law passed by Congress if it violated the Constitution, legally cementing the power of judicial review.
Yes. So let me back up and just say that Adams was clearly diselected. He knew it. There was no ambiguity. He was frightened of what I might do. I called my election the Second American Revolution, and I was disenchanted with much that had occurred under the Federalist 12 years that had preceded me. And so to forestall that, to prevent that, he used the judicial branch as a kind of bulwark to try to shore it up to prevent me from doing the things that I wanted to do to change the direction of the country. He wanted to prevent me from doing that. And so in the last hours of his administration, he appointed people who were known to be antagonistic to my view, including my cousin from Virginia, John Marshall. And when Marshall was confirmed, he became the Chief Justice of the United States. And in fact, he served all the way through my term. And then he served all the way through Mr. Madison's 8 years. And then he served all the way through James Monroe's 8 years. And then the years of John Quincy Adams. He served from 1804 to 1834. He served for 34 years as the Chief Justice of the Supreme Court of the United States. That's one thing. That does not show, I think, anything like the principles of a democratic republic. But secondly, he was an ardent Federalist nationalist. And so when cases came before him, he didn't decide them according to their strict legal merits. He decided them in order to shore up the national government, to make it stronger, to make it more emphatic, to swallow up the sovereignties of the states, and in some ways to nullify the 10th Amendment, which says that states are a co-sovereign under our system. And so he had enormous influence. He was perhaps the most influential Chief Justice or any justice of the Supreme Court in American history, and he was certainly entitled to his view of things. But should he have had 34 years through a number of Republican, not Federalist administrations, which disagreed fundamentally with his judicial outlook, should he have had that power, which he asserted in really emphatic ways over the other justices? He was by far the most important of the justices, and they all deferred to John Marshall. That's more power than any single individual should ever have in a republic, and it is certainly more power than an unelected and unaccountable being should have in a republic.
But Mr. Jefferson, you emphasized earlier that what Adams did was the right of any president, even facing defeat and end of his term.
Yes, he had the absolute constitutional right to do exactly what he did. I don't think that it was gentlemanly. I don't think that it was democratic. I don't think that it was good for the country. But if you're asking whether his appointments were legitimate, I must affirm that they were. And I should tell you that, as you probably know, that in the exchange of letters that I had with his wife, Abigail Adams, in 1804, after the death of my younger daughter, we actually moved into this arena. I made the mistake of saying that one thing and one thing only in his administration had offended me personally, and that was these midnight appointments, which I thought did not show a real sense of gentlemanly decency. And she wrote back, as I'm sure you know, a blistering letter, one of the most blistering letters that I ever received from anyone. And she said, "Look, Mr. Jefferson, let me give you a little lecture on constitutional theory. The president is the president from the moment he's inaugurated until the moment that he leaves. His duty is to do what presidents do during that entire period. He had an absolute right to make such appointments as he did, and you are completely wrong on the legitimacy of those appointments, whatever you might think about their gentlemanliness." And so I have to acknowledge that she was right, but I tell you that if the situation were reversed, I can promise you I wouldn't have done that, because I didn't when Mr. Madison was going to be the next president for the whole year before that. Whenever an important decision came to my desk, I thought, if I can, I should defer that so that James Madison can make his own decisions and he can produce an administration that is completely harmonious with his own public will and his personal will. And I think that, in fact, is the kind of gentlemanly deference that makes it a republic. A constitutional system does not have to involve decency. Nothing in the Constitution requires decency. But in my opinion, it only works with a high level of mutual respect, mutual forbearance, the search for harmony, and great decency. And I hope that distinction is useful to you.
Very much so. Were that we could successfully legislate decency. There is a letter that you wrote that's fairly revealing. You wrote it from Poplar Forest in September of 1819 to a Judge Spencer Roane, and I want to read just a paragraph or two from that back to you. You wrote that each department is truly independent of the others and has an equal right to decide for itself what is the meaning of the Constitution in the cases submitted to its action, and especially where it is to act ultimately and without appeal. The Constitution, on this hypothesis, is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please.
Yes, so I do believe that John Marshall and his court, which he dominated in a way that probably no other Chief Justice has ever dominated, bullied the nation into being a much more centralized entity than was intended by the Constitution makers who met in Philadelphia. And I do believe that he twisted the Constitution to suit his political outlook, that he was not a neutral arbiter of cases that rose to his attention, but that he used his time on the court to turn the country into a much more centralized and high-handed entity than had been contemplated in Philadelphia. Well, fair enough. However, there's another important doctrine in that letter, and from the paragraph that you quoted. I believe that the court does have some legitimate power of judicial review, and I've already outlined a case in which, say, the First Amendment was trampled by a sedition act. But so do the other two branches. In other words, each branch has a right to interpret the Constitution, absolutely where there's no check, but in coordination with the other two branches where there are checks and balances. So I said in a letter to George Washington that he should never veto a bill, even if he disagreed with it from a politics point of view or a policy point of view, unless he felt that it was actually unconstitutional, that if the Congress passed a bill that he thought was foolish, as long as it was constitutional, he should probably swallow hard and sign it. But he should protect the Constitution from the Congress of the United States should it do something that violated one or other provisions of that fundamental document. And I believe that each of the three branches has that power, that we should not limit the power of judicial review merely to the Supreme Court, that power needs to be shared. And I'll take it one step farther. Not only should that power of interpretation be shared among the three national branches, but it should also be shared between the national government and the state governments. The states, who are, after all, a fundamental part of the dual sovereignty of our Constitution, should be able to step in and say, all three of the national branches have passed such and such a law, but it does seem to violate this provision of the Constitution. Therefore, we demand that it be re-examined, or, in extremity, we refuse to enforce that extra-constitutional national legislation within the bounds, say, of Maryland or of New Hampshire.
Thank you, Mr. Jefferson. We need to bring this conversation to a close at this point, but it's been very enlightening. I guess the thing I step away from this talk with you is that democracy is, well, it can be a bit messy, sir.
It can be messy, and I hope the distinction has been clear to you and everyone who is listening, that just because it is constitutionally legitimate does not make it useful in Republican theory, that a republic is a very delicate and fragile sort of thing, and it depends on a high level of mutual respect, mutual forbearance, civility, deference, and an attempt by the majority to reach out overtly to embrace the minority and find whatever consensus is available. Without those qualities of harmony and mutual respect, you can be a nation, but you decidedly cannot be a republic.
Thank you so much, Mr. Jefferson.
You are welcome, sir.
We're going to take a short break, but we'll return in just a moment. You're listening to the Thomas Jefferson Hour.
Welcome back, everyone, to the third segment of the Thomas Jefferson Hour. I'm Clay Jenkinson. I have shorn my tights and my wig and my ruffled shirt and my buckled shoes, and I am now electronically sitting across from the semi-permanent guest host of the Thomas Jefferson Hour, Mr. David Swenson.
Yeah, I have to interject. During the break, I was talking, and it's weird, but we've kind of gotten into this new norm of how we do the Jefferson Hour because of the pandemic. You're one place, I'm another. And I said to you, this conversation with Jefferson this week was so deep. I mean, I'm sitting here with my eyes closed having this conversation, and I'm seeing Jefferson. I'm not seeing you. It was pretty good.
Ding, 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 ding.
Yeah,
that's
something like
that's
that.
my
Yeah.
Twilight Zone sound. Yeah, I feel the same way. When I was interviewed last week by somebody in Colorado about the work that I do, and he said, what happens when you're performing? And I said, yeah, I know this is going to sound like new age mumbo jumbo, but in some sense, I become Jefferson. I get thin-skinned about things that he's upset about, and I get passionate about things that he feels passionate about. And
When you used to come to the studio, the lights would sort of flicker, and I'd see
I
your arms
recall,
roll
yeah,
back.
lightning would strike. But here's what's so important. We all know that with the death of Ruth Bader Ginsburg, we have moved into a much deeper national political crisis than we were already in, and it was already huge. And now we're facing one of the most volatile, controversial, maybe even insane 12-week periods of our history, certainly of my own lifetime. And I think that every thinking person, every rational person is anxious, no matter what's your party. And we all are wondering, how is this going to come out, and what does it mean, and what precedents are being set, and will we be able to recover from this? Will the system entirely break down? Will there be a smooth transition? Will there be a backlash to one party or the other, or both, over the way they try to handle the vacancy of Ruth Bader Ginsburg, and so on? And here's what's so important, David. The humanities help us when I've been perplexed about this, and frankly losing sleep over it since Friday night. But when I turn to Jefferson, I find assurance and clarity. So what did he tell us today? Yes, Donald Trump and the Republican majority in the Senate have an absolute constitutional right to fill that vacancy. The president is the president for his entire period in office, and that there is no question from a constitutional point of view about whether the president can legitimately do that. Now, that would make him and others hypocrites because, of course, back in 2016, they made a very big deal out of the proximity problem that selecting somebody in the same year as a national election was a mistake that the Senate should not make. And now, of course, we're only a few weeks before an election, and it turns out that the very people who spoke with such deep commitment to national principle at that time are contemptible hypocrites, because they have completely reversed their point of view now that they have the opportunity to do just what they prevented the former president from doing. So they have a political right to do it. But Jefferson's theory that in a republic there has to be something more noble, there has to be some principle of selflessness, there has to be some principle of mutual respect, that just seems quaint now in our time, but he meant it. And so this is how it really helps to look at this. And I looked at his 3 appointments, and here's the most interesting thing about this, David. I've got the list right in front of me. He appoints William Johnson on March 22nd, 1804. He was confirmed 2 days later. He appoints Henry Brockholst Livingston on December 13th, 1806. He was confirmed 4 days later. And his third and final appointment, Thomas Todd, on February 28th, 1807, he was approved on March 2nd. All within a week. Each of Jefferson's 3 appointments was approved within a single week of Jefferson's nomination. What does that tell you? It tells you...
Well, does it maybe that the Congress, the Senate had more respect for the presidency than they do now? It's less politicized?
Yeah, of course, Jefferson was the president, and both houses of Congress were of his political party, so there was a kind of a solidarity that doesn't exist in our time. But it also shows that the stakes were lower. That, today, and this all goes back to the failed appointment of Justice Robert Bork in 1987. Today, this is the most high-stakes political game in the country. In some ways, it's more of a high-stakes moment than the presidential election itself, because if the president, say, appoints a 35-year-old person, either a leftist liberal or a rightist conservative, that person could serve for 60 years.
But did they during Jefferson's time? Like, I know you said Jefferson said Marshall served for 34 years, but on the other hand, John Jay only served for 3.
But I looked up Jefferson's 3 appointments, and it again is staggering what history teaches us. William Johnson began service in March of 1804, served till 1834, 30 years. 30 years. We always talk about Marshall with his 34 years. William Johnson, who's basically historically a non-entity, served for 3 full decades. Henry Brockholst Livingston began service in late 1806, served to 1823, 17 years. Thomas Todd, who began service in March of 1807, served until 1826, a period of 19 years. Now, admittedly, this was during the Virginia dynasty, so Jefferson 8 years, Madison 8 years, Monroe 8 years. So you have basically a government phalanx under one party for a quarter of a century. But those 3, and none of them is a shining star in the history of the Supreme Court. The lowest number of years, Livingston at 17, the highest number of years, 30, for William Johnson. So, yes, people didn't live as long back then, and most people didn't serve that long. But Jefferson's 3 served longer than I think Jefferson himself would have been comfortable with had he followed it.
The Marbury versus Madison case we've talked about a lot, but I mean, that really was a benchmark where it said, all right, the court has this much power that has lasted since then. Is that fair to say?
Yes, a couple of things about that. First of all, Marbury v. Madison is the first course that students in constitutional law at law school take. And this was 1803. What happened was that William Marbury was nominated by Adams to a very minor post, a justice of the peace post, and things were so chaotic in the last days of Adams' administration that his legal commission, the actual document, wasn't put into his hands. It was still on the desk in the State Department when James Madison took over. And Jefferson, who was angry about the midnight appointments, was asked by Madison, what should I do with, there were a number of them, with these commissions that were written but were not physically delivered to the intended recipients? And Jefferson said, just throw them away. If they weren't delivered, there's no way we're now going to deliver them on behalf of the former administration. And so William Marbury sued to get his commission, and under something called a writ of mandamus, which means hand it over. And the court sat on this, and Marshall spent a lot of time thinking about how to handle this. And eventually he did not give Marbury the commission, and here's why. He said the provision in the Judiciary Act of 1789 that allows writs of mandamus in situations like this was unconstitutional, not the whole law of 1789, but that provision of the 1789 Judiciary Act. It was unconstitutional. It doesn't meet the standards of constitutional legitimacy, and therefore I can't give Marbury his commission because he's suing under a provision that doesn't have any actual constitutional basis. And so, in a way, he sides with Jefferson. He doesn't deliver the commission to Marbury, but B, he installs the notion that the courts are the final arbiter of what is legitimate, our concept of judicial review. That is not in the Constitution of the United States. It's sort of semi-implicit, but it's not enumerated in the Constitution. And that's why Jefferson could write to Spencer Roane in 1819 saying, each of the three branches of the national government has powers of judicial review. Every judge, legal scholar, and lawyer that I've ever talked to about this, David, has said, thank goodness Jefferson didn't get his way. Because if you think it's chaotic now, when the Supreme Court is the final arbiter, imagine what it would have been like if they were all weighing in on all of these questions.
It's hard to imagine more chaos, actually. This has been a very enlightening conversation. So good to hear Mr. Jefferson this week. I know you would join me, sir, in condolences for the passing of Justice Ginsburg.
The thing that has struck me most, David, is the level of bipartisan respect for her. There have been some exceptions, and they're really disgusting ones. But on the whole, she has been seen by people of all political persuasions in both parties as a colossus of the courts and one of the great human rights advocates of our time. And that has been so moving to me. I will just say in closing, I once had a question from her at a judicial conference where I was performing as Jefferson, and she stood up and asked me a question. She was new then. President Clinton had just appointed her, and she asked a question about women's rights, and I gave the usual stupid Jefferson answer that women's best happiness was in the nursery, and she laughed out loud. She didn't agree, of course, but she laughed out loud because she knew that I was being historically accurate to the way that Jefferson saw gender questions in his own time and his own place. I think we grieve for Justice Ginsburg, and I think we can say we shall not see her like again.
What a great memory. Thanks for sharing that. And as we have spoken with President Jefferson this week, and which pleases me greatly, I'm also very pleased to say that, sir, it is now time for this week's Jefferson Watch.
I don't know much, but I know this much. If we were still a republic, the party in power would delay filling the vacancy of Ruth Bader Ginsburg until after the inauguration of the next president on January 20th, 2021, whether that president is Joe Biden or Donald Trump. The whole idea of a republic was that our elected officials would be men, and now women, of great integrity, people who put the country first and the people first, political figures who would restrain their selfish interests and instincts severely. In a republic, elected representatives are constantly trying first to discern the will of the people, all of the people, not merely their own party or tribe, and then to fulfill that will by way of legislation and public policy. I don't think anyone really knows what the will of the American people is at this point in our national experiment, partly because the people are mostly watching reality television shows. And I know this: if we were still a republic, the people would punish Senators Mitch McConnell and Lindsey Graham for saying emphatically back in 2016 that it was a sacred principle not to fill the court vacancy within 7 months of a presidential election, and now, with gross and colossal hypocrisy, declaring just the opposite. The Founding Fathers believed that a republic only works if our leaders have real character. The people actively exercise their sovereignty, and the people hold our elected officials strictly accountable for consistency. Jefferson blamed John Adams for packing the U.S. court system with midnight judges in the last hours of his one-term presidency. Adams appointed a number of judicial officers when the election results were in, when he knew that Jefferson would soon be replacing him. He did this to tie Jefferson's hand, to prevent what Jefferson called the Second American Revolution from success. One of Adams' last-second appointments was Chief Justice John Marshall, who went on to have a 34-year reign on the Supreme Court. Jefferson believed that the people had spoken in the election of 1800. Now it was up to their representatives to honor the will of the people, even if that meant surrendering their own self-interest to the public good. Jefferson told Abigail Adams that it was a matter of common decency for an outgoing president to leave all important decisions, including staffing decisions, to his successor. Abigail Adams countered with some snark with the argument that a president is entitled to do all the things he was elected to do right down to the moment when his successor takes the oath of office. And I know this certainly too. If this vacancy had occurred on George Washington's watch, he would have stepped back to ponder what was the best thing to do for the good of the people of America. Fill the vacancy or not fill the vacancy, and then he would have done that thing unhesitatingly. In other words, back then, we were still really trying to be a republic. It was not about raw exercise of power. It was about the common good. It was about respect for the sovereign. It was about the will of the people. It was about doing the best thing for the country. But we have reached so low a nadir in our political history that it is now seen as merely quaint, even stupid, to think that people in power will do the right thing instead of the expedient and the self-interested thing. And by the way, I am not at all sure the Democrats would not do precisely the same thing about a vacancy on the Supreme Court if they were in power today. It is we the people who have to demand that both parties and all politicians behave with actual integrity. We know that the Republicans declared 4 years ago that it would be a violation of constitutional norms to fill a vacancy months before an election, and then said on camera that they wanted to be held accountable if they broke that vow. Now they are breaking that vow, and when the video clips of them saying they wanted to be held accountable if the shoe were ever on the other foot are played for them, they just shrug and make up some pathetic justification for the hypocrisy that doesn't convince their enemies or even their friends. They don't care. Power is power. Nothing else matters. And yet another guardrail of our constitutional system collapses. If the Republicans go back on their word and fill the Ginsburg seat, we will have descended to yet another lower level of national fairness and civility. When the Democratic majority retakes the presidency in Congress sometimes in the next 5 years or 15, we can expect them to use their power just as ruthlessly, and they will justify their actions by reminding everyone what the Trump administration and the Republican Senate did in the autumn of 2020. Such notions as senatorial courtesy and the common good will be dismissed as naive fossils of a foregone era. It's like Dante's Inferno. We just keep descending together into greater depravity and corruption and naked power, and at some point the republic just breaks. All those analogies about the decline and fall of the Roman Republic that we have been hearing about for the last 50 years suddenly don't seem so far-fetched. We may actually be experiencing the beginning of the collapse of our constitutional republic. We made the mistake of believing that our constitutional system was more robust than it actually is. We are learning the hard way that the system only worked if there were a mutual respect for our basic institutions and our basic norms. Such things as the independence of the Department of Justice, the sanctity of the Centers for Disease Control, and the peaceful transfer of power after a national election. Those institutions and norms cannot be sustained unless all major parties agree to honor them and abide by their principles. Nothing in the U.S. Constitution requires President Trump to wait around until after the next inauguration to fill a Supreme Court vacancy. Many of the props and guardrails of our constitutional system are voluntary. We used to think that was enough. It looks as if we may have been complacent and that the system is far more fragile than we reckoned. I believe in the basic fairness of the American people. I believe they are better than our politicians. I think they are better than the distortions of our partisan media. And I actually believe they are better than they know. When push comes to shove, all that really protects us in life is the golden rule. Do in every situation what you would want the other guy or party or country to do if the situation were reversed. If you think about it, it's very hard to improve upon that code. I would like to say that I'm not going to stand by and watch America descend into autocracy. But what, in fact, can I do about that? That is the source of my despair. I'm Clay Jenkinson. We'll see you next week for another important edition of the Thomas Jefferson Hour.
The Thomas Jefferson Hour is brought to you each week by Dakota Sky Education. The program is distributed nationally by Prairie Public. President Thomas Jefferson lived from 1743 to 1826, and this program presents his views. President Jefferson is portrayed by the award-winning humanities scholar and author Clay S. Jenkinson. To obtain a copy of this or any show for a $12 donation, please call 701-575-0727. This program is also available online at jeffersonhour.com and on Apple Podcasts. If you'd like to correspond with President Jefferson or submit a question for him to answer on the program,